Can you plead the fifth when asked a question during your civil trial here in New York? You want to know the answer? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer most likely is no, you cannot take the fifth, which means you're asked a question by the defense attorney on cross-examination, and rather than you answering it, you turn around, I plead the fifth on the grounds that anything I say might incriminate me. Now, can you get away with that? In all likelihood, the answer is no. You want to know why? That typically occurs in a criminal matter. But in a civil lawsuit where you are seeking compensation for all the harms, the losses, the damages that you incurred because of someone else's carelessness, maybe it was an accident matter, maybe it was a careless driver or careless doctor or hospital staff, you cannot refuse to answer a question because you are pleading the fifth, claiming that anything you say might be used against you and to incriminate you or to incriminate yourself about something you've done. That doesn't work in a civil trial. Instead, in all likelihood, you will have to answer the question. Now, there are certain topics that might be uncomfortable for you to answer, such as sexual function and your relationship with your spouse. Well, what about if you are claiming lost earnings? And now in your tax returns that you provide to the defense, they're now going through certain things that raises red flags. And now they begin to ask you questions, and you turn around and say, you know what? I'm not answering that question on the grounds that anything I say might incriminate me. What does that mean for you in your case? I'll tell you what it means from a civil standpoint. If you are at trial and are on the witness stand, and now the defense attorney asks you a question that you feel is very difficult to answer because it might create other criminal possibilities for you, the jury is going to get very suspicious. The jury is going to look at you as if you've got something to hide. And if you've got something to hide and they know it, they see it, now all of a sudden your credibility is shot. And the biggest thing, the biggest component of your entire trial is your credibility. Everything rests on your credibility, on your expert's credibility. And if your credibility is destroyed, if your expert's credibility is ruined, guess what? Your case is going down the tank, going downhill. The moment you begin to raise issues about your credibility, even if it's got nothing to do with the issues that you're bringing in this case, about whether the doctor treated you appropriately or whether the driver crossed over the double yellow line, all of a sudden the jury looks at you and says, wait a second, something's not right here. He's hiding something. What's he hiding? Why is he hiding? And regardless of why you are refusing to answer that question, now it raised doubts. And the moment your credibility is impaired, now you are severely risking what happens to you and your case. So why do I share this information with you? I share it with you just to give you an inside look of what really happens in these civil trials here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you haven't brought a lawsuit yet because you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer questions just like yours. I do this every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.